in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, the National Assembly had no difficulty approving now to become the deputy president. It is that uneven-handed that the National Assembly had no difficulty approving now to become the deputy president. Then sought to establish it is that uneven-handed to be then found the deputy president. That the National Assembly had no difficulty approving now to become the deputy president. It is that uneven-handed to be then found the deputy president. The reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the Speaker of the Senate fell way off the mark. Mr. Dudley, you're welcome. Thank you, my Lord.
Thank you. Thank you, my Lord, for the opportunity to address you on this important question. When we last left the court, I had thought that we were done with jurisdiction, but the National Assembly spends the first 32 pages of their submissions saying that you either lack jurisdiction, or if you have it, then you're limited to looking at the process. And you should not hear the substantive violations that my two colleagues have told you about. They cite, quite helpfully to us, a Filipino case, Francisco versus House of Representatives, where the Filipino Parliament had similarly argued that the Filipino judiciary had no jurisdiction to review impeachment proceedings. The court concluded that that process has procedural safeguards, and therefore it answers to a legal process. My Lord, that stance, the stance that the proceedings you're dealing with are both political and legal, is found in the report of the Technical Working Group D on the executive. My senior counsel team leader, Paul Mwit, was a delegate number 114. The current speaker was delegate number 209 at the CKRC conference. And you'll hear Professor Gidhum Wigai, when he rises, tell you that these provisions on impeachment were hotly contested. They were the most contentious provisions. And so, my Lord, detail was paid to these provisions. The law is that Parliament does not waste words. Every word in a legislation must be given a meaning. Now, let me begin with what's common ground. On 9th October 2024, JN4, the affidavit of Jeremiah Nyegenye at paragraph 22, the morning sitting, in the Hansard, the Speaker of the Senate misleads the Senate, saying that we have two options to deal with this motion, unlike the procedure for governors and deputy governors. It says we have a motion is the first for impeachment of deputy president, but we have two options that we have when it comes to the impeachment of deputy governors and governors. My Lord, that is a heresy. And because of that, just common ground again, the Senate does not form the committee. The special committee under Article 145(3) is not formed. Why? The Speaker misleads the House that they have two options. They can either investigate the charges by committee, Article 145(3)(a), or they can investigate by plenary, like they do for governors. My Lord, I request that my Lords be given our rejoinder submissions, table 1, because I intend to spend a moment or two there. My Lord, the Senate picks the 10-day timeline applicable to the special committee. Remember, they've dropped the committee. They've said, no, we have two options. We are investigating it in plenary. But they retain the 10-day timeline applicable to that special committee. And so, when the deputy president falls ill, my colleagues have addressed this, the Speaker holds on to the 10-day deadline applicable to the special committee for a plenary hearing. And the members of the Senate vote to deny the deputy president even the benefit of that 10 days, the balance of it. They say we must conclude our business today. In doing that, the Senate grossly violated the Constitution. My Lord, let me bring your attention to Table 1. In Table 1, we've tabulated the differences between Article 145(3), Senate Standing Order 78 and 80, and Rule 2, Rules of Procedure for removal of the Deputy President by impeachment and governors. My Lord, Article 145(3) does not give two options. It gives one option, and it says that within 7 days after receiving notice of the National Assembly resolution, the Senate Speaker shall convene a meeting of the Senate to hear charges against the President. And the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter. The special committee has a constitutional function. It investigates the charges for seriousness. Then it reports to the Senate. My Lord, there's a may which seems problematic here, but we'll tell you where that may originated. But as it is, it makes grammatical sense. The Senate must convene within 7 days, and if the Senate convenes in 7 days and the motion is approved, there's something worthy of investigation here, the Senate may appoint the committee. It must not appoint the committee always. Why? Because sometimes you'll find that it's flimsy. The charge is that the deputy president, the president, wore a yellow shirt. He should have worn green. Or he wore a blue shirt when he should have worn a red one. Flimsy charges. My Lord, the test on threshold has already been laid to you. So literally, grammatically, Article 145(3)(a) has an and. If you go to 143(5)(b) and you begin with the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter, and you leave the A, what have you done to the and? And is disjunctive. It means you must bring both elements of the law together. Parliament does not waste words. Every word used by Parliament in a law has meaning. And the court must give each word in the law meaning, especially if that law is a constitution. My Lord, staying with Table 1, Standing Order 78, which is a provision applicable to the President, reflects faithfully the wording in Article 145.3, word for word. Then, this is where the original sin happens. Standing Order 80, and that is on page 2 of our Table 1. I really hope that my lords have it so that we take this argument, because it's a technical one and it's on the details. But when you come to Standing Order 80, which is the procedure applicable to governors and deputy governors, it allows the Senate to investigate in plenary. Standing Order 81 says, within 7 days after receiving the resolution, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the governor. And the Senate may, 1, by resolution, appoint a special committee comprising 11 of its members to investigate the matter, or investigate the matter in plenary. The Speaker imports this "or" in Standing Order 80, brings it to Standing Order 78, replaces the "and" there. The Senate shall convene and may by resolution appoint a committee. He replaces that "and," he deletes it. He uses "or." So he tells the senators, you have two options. You can go investigate this by special committee, or you can investigate it by plenary, like we do for governors. My Lord, if you look at the constitutional article for impeachment of governors, you will not find the kind of detail that you have in Article 145. Why? My learned friend, my senior Professor Guido, will tell you that this Article 145 was intensely debated. It was one of the most contentious provisions in the history of the making of the Constitution. So it comes complete with detail. But the Speaker here replaces the word "or" in Standing Order 80 and takes it to Standing Order 78 to Article 145.3. He deletes "and" implants "or." What misled the Speaker could be is Rule 2. My Lord, that's the last item, number 4, on page 2 of our Table 1. Rule 2, Rules of Procedure, also makes the same mistake. It replaces the legislative word "and" in Article 145 with the "or," disjunctive. My Lord, Rule 2 says the Senate may in plenary investigate the matter and determine whether the particulars of the allegations against the President have been substantiated. It has now omitted. The special committee is gone. So Rule 2 goes to 145.3 and then descends to B by plenary. It's saying the Senate may investigate by plenary. Where did this error originate in the making of our Constitution? My Lord, I go to that because if, suppose we are not making sense and our argument is too full of grammar, the theory of holistic interpretation requires you to look at the text, which we have done, and the history. What was the history? And how did we end up with a provision that, quote unquote, could sound difficult? My Lord, the theory of holistic interpretation is mainstreamed as a theory of interpreting our Constitution. Let us then travel back in time to the Bomas Conference. But my Lord, before I do that, allow me to draw your attention to a fresh new publication of the Senate. And that is a digest of the law and practice on removal of county governors and deputy county governors from office through impeachment. First edition, brand new, published last year. I apologize, I haven't yet produced it to the court. I intend to do that, but it's also available online, thanks to the Senate. My Lord, the Senate worries about this process. It says committee vis-a-vis plenary proceedings. And the Senate, this is about governance. It says that the law does not provide for any specific procedure. Page 104, a case digest. You do not have it yet. I've just apologized that I came across it yesterday because it's a new publication, but I will put it on record. When you turn to it and you look at page 104, you find that the Senate says that the law does not provide for any specific procedure. As a result, the county assemblies and the Senate are not bound to follow any route. That is what informs the rules of procedure, where the Senate may investigate. And that is also what informs Standing Order 80, where the Senate may use plenary to investigate. But, my Lord, the Senate recognizes what this court has in Sonko High Court. This court said that we are of the considered view that impeachment of a governor is a serious undertaking. The impeachment of a deputy president, of a president, is a more serious undertaking. For this reason, we recommend that it will be desirable in future impeachments to proceed through the committee route as opposed to the plenary. This High Court has recognized the inherent risks in investigating through plenary. Why? We say so because when the special committee is appointed, the Article 145(3)(a) committee, it has 10 days to deliberate on the matter, thus giving many opportunities to the parties to prepare their cases adequately. The committee gives the perception that each member is actually engaging in the process as opposed to the plenary, which can be perceived to be a mob lynching process. That's exactly what happened here. The investigation in plenary was a mob lynching process. The Senate goes on to say that trial by the committee, page 105, a case digest on removal of governors and deputy governors, a publication of the Senate, brand new 2025 bond. Trial by committee gives the Senate, through the 11 members, an opportunity to review the usually voluminous documents from the governor's team. A trial by committee over the 10 days would have given the Senate the time to review.
As a request, we clarify the record while my colleague is addressing that point. In his written submissions, that decision is describing, it is described as a decision of the Supreme Court, but it is actually a decision of the High Court. So that we don't have to later belabor this point now that we're addressing it. Can he confirm? Because the written record says it is a decision of the Supreme Court, but it's actually a decision of the High Court.
I'm grateful that my learned friend, Mr. Mudomi Tiankula, a very good friend of mine, felt compelled to interrupt at this point, indicating its importance. It's an easy one. The decision is High Court, Sonko. There's a typo saying it's Supreme Court. It's High Court, but it's what the court has said. Now here, at page 105 where I was, the Senate is speaking to a member of staff of the Senate involved in this process. That's what this report highlights there. And this member of staff, I hope it's my learned friend, Ms. Tanji, is saying that trial by committee, the special committee under Article 145(3)(a), gives members and would have given the deputy president's team enough time to interact with the senators on the voluminous record. Because of the fewer members, the committee is able to probe and follow up with specific questions, especially where the grounds for impeachment are technical. Perhaps the committee would have caught out that in Robert Alai, a case I was fortunate to argue with my learned friend, Mr. Ongoya, the court had already nullified Section 132 of the Penal Code on undermining the authority of a public officer. My Lord, this did not happen in this case. And finally, it records here that the plenary, it also says that there are some benefits to the plenary report as well. My Lord, in short, what you are saying is that the motion to impeach the deputy president was contingent on the special committee's report. It's not just procedural. There's also a substantive right given to him before that committee. Look at Article 145(5) of the Constitution. The deputy president has a right to be heard before that committee. The committee investigating the serious charges leveled against him. That step was omitted. That's a grave violation of the Constitution. My Lord, the final chance that he had to be heard was also denied to him, the adjournment. When something like that happened, in a case that my friend, Professor Ojenda, Senior Counsel, argued with his usual merit, Onyango Law versus Kisumu County Assembly, Service Board, 2025 Kenya Court of Appeal 333. The Court of Appeal was persuaded that Onyango Law had been denied a fair hearing. And just like in Oloma Law, the Senate here speedily approved the motion, skipped that special committee altogether, but retained the 10-day timeline. I wonder if the 10-day timeline was doing in a plenary setting where the Constitution does not impose that 10-day timeline, but requires reasonableness. It obviously can't delay. But that 10-day timeline was a stranger in the process. And so the Court of Appeal was persuaded that Onyango Law was unfairly impeached. My Lord, we ask you to take the Onyango Law decision and...
I don't like interrupting things at all. But just Onyango Law was given 1 hour. The Deputy President had 10 days.
My Lord, whereas the special committee would have had the deputy president over 10 days, he was investigated in plenary over 24 hours and impeached in his absence. So I ask you again to take the Onyango Law decision, and where it says Onyango Law, please substitute Rigathi Gachagua and make your decision. My Lord, let me take you to the drafting history of our Article 145. It was not initially there as Article 145. And my Lord, the theory of holistic interpretation requires you to consider our social, our political, our historical context as a people. That history has names like Oginga Odinga, mistreated by the president, unfairly removed from office. It has Kungu Karumba, George Saitoti, at some point not appointed at all, reappointed after the elections. I forget which year, I was a young boy then. But in your ruling of 31st October 2024, my Lord, you recognize this history, and you said that the vice president served entirely at the president's mercy. That was a framework that the 2010 Constitution sought to transform. And under the 2010 Constitution, the office of the Deputy President is fundamentally redefined. Your words? It was safeguarded from arbitrary and capricious actions by the President. Before the Senate, on 16th October 2024, another good friend, Senior Counsel Otiende Amolo, a former member of the Committee of Experts, who was familiar with the drafting history of Article 145, reflected as follows, and I quote, "Before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The president would sack the vice president at whims, including for not liking the color of his shoes. So my example of the color of his coat was not so far-fetched. It is on the answered record. My Lord, that's a correct reflection on the intention, on the history, on the motivations, on the framing of Article 145. In the National Land Commission versus Attorney General Supreme Court advisory opinion, the court held that unlike the independence constitution that failed to articulate the history and struggles of the people, the 2010 Constitution integrates that history and the people's view. And so, my Lord, when you turn to interpret Article 145 and you encounter the challenge with the may appearing in the second part of it, in 135 3b, and you wonder why does it appear this way, you must remember the history. Speaking of history, at page 182 of the CKFC final report, and that, my Lord, is a lawyer's Bible, it is a constitutional lawyer's Bible. It is the reference point for ambiguous text. We go back to it to see what was the intention here, what was the struggle, what was the mischief. The people said that, I quote, there should be adequate mechanisms to avoid the risk of impeachment being used for purely political motives. Page 802 of that CKFC final report records that impeachment was one of the most contentious issues leading to extreme polarization amongst delegates. And the issue was not about the desirability of impeachment. No, it was about the procedure. What procedure do we use? Because we agree that the president must be amenable to impeachment. It is a remedy of last resort. But what procedure do we use? My Lord, in the Bomas draft that came out of that conference, the CKFC proceeding, we had Article 164. Article 164 of the Bomas draft is an exact replica of today's Article 145, except it had a bit more clarity. Why? Because the kind of Thank you, my Lord. My Lord, because the kind of contestations that attend the making of any constitution had not been there. Remember, by the time we are getting to 145, we've gone through a failed referendum. We've had the WACO draft. We've also had the Naivasha process that messes up and moves articles around. So back in Bomas, Article 164, this is what 164.4 said. If a motion is passed under Clause 3, Clause 3, the Speaker of the Senate is considering what has come from the National Assembly. The Senate shall appoint 13 of its members as a special committee in accordance with the standing orders to investigate the matter. So this committee was there, 164.4 Bomas draft. The special committee shall investigate the matter, 164.5 Bomas draft, and shall within 10 days. So the 10 days is also there. It's not a new invention under 145. 164 Bomas draft had it. And the president shall have the right to appear and be represented before the committee. So this right also to be heard before the committee was also there. 164 Bomas draft. My Lord, we then had the Guy draft, 163. This clause appeared at Article 163 of the Guy draft, and it also said that if a motion is passed under Clause 2, the Speaker shall constitute a special committee comprising the Chief Justice and 13 members of the National Council. So even when this committee was thought the Chief Justice should sit on it, it was there. When the name changed to National Council, the committee was there. It has consistently been there. Article 163.5 of the Guy draft provided that the president would have the right to appear and be represented before the special committee. So when it was Article 163.5 and not 145.5, the Deputy President right to appear was there. I take you next to 2009 Harmonized Draft Constitution by the Committee of Experts. My Lord, 163.4 of the guide draft also required the committee to investigate. So its function was there. Its composition changed a little bit, but the entitlement to appear before this committee and to be heard during the investigation of the charges was consistent. Article 170, 2009 Harmonized Draft. Now we are getting closer to the referendum. 173, upon hearing the charges under Clause 2. Article 173, 2009 Harmonized Draft. Upon hearing the charges under Clause 2, the charges approved in the motion that has come from the National Assembly, the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter. So the number is now at 11. And the special committee shall investigate the matter within 10 days and report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. The President, you can guess, shall have the right to appear and be represented before the special committee during its investigations. My Lord, now we go to Naivasha. A constitution is a political charter. It will have vagueness of phraseology. Why? Because you need to get consensus and have the document passed, or you have no constitution at all. And so we take it as it comes, with ambiguity. But that's not the kind of ambiguity that scares this court. The court would be adept to interpret the Constitution together with those ambiguities, understanding its history. Now, ambiguity is coming in. Naivasha, the Parliamentary Select Committee, a committee of politicians. They moved this clause to Article 127.3. And they're saying, upon hearing the charges under Clause 2, the National Assembly, now, you know, they're also shifting it from the Senate. They're bringing it to the National Assembly, Naivasha. The National Assembly may, by resolution, appoint a select committee comprising 11 of its members to investigate the matter. My Lord, from 127.3, Naivasha, it gets back to 145, and it brings with it the main, which is there today. That's how it sounds vague. That's why it appears ambiguous. My Lord, throughout that history, the 10-day period is there. I am concluding, my Lord. The function of the committee, it's okay, my Lord. The function of the committee is also there. And the Deputy President's right to appear before it is there. And so, when on 9th October 2024, the Speaker misleads the House, telling it that you have two options. What is the source of that authority? Where does the Speaker get the right to amend the Constitution in his directions to senators? What gives him the right? It's not even in the standing orders. My Lord, he fuses, the Speaker fuses Standing Order 78, Standing Order 80, the Rules of Procedure, and Article 145. And in that process, Article 145 suffers violence.
Just clarify, you said that it appears ambiguous.
Yes.
It's ambiguous.
It is not ambiguous. If you look at its history, if you look at its intention, if you consider that constitution making, Speaker of the Senate versus Attorney General, is a political process, it is quite clear. The Senate may appoint that committee if it finds that there's something to be investigated. My Lord, blue shoes, nothing to investigate. What's the committee to investigate? But if there's something that appears plausible, there's something that needs some kind of investigation, then the Senate must appoint that committee. So the May turns to must. It must only appoint if there's something to be investigated. If it concludes that there's nothing to be investigated, the malicious and malicious compliance, if there's nothing to be investigated, it doesn't need to appoint the committee. My Lord, let me move forward and say that in Speak of the Senate, the Supreme Court explains precisely this kind of phenomenon, where the document born out of long-drawn negotiations, 2002 when I was a schooler to 2010 when I joined the university, long-drawn process. The document is looked at, touched by many hands. For the Constitution in 145.3a and the May in 145.3b, and to those who are contradictions, where you have a shall in 145.3a and the May in 145.3b, and to those who are mischievous, it appears to be ambiguous. Political and social demands of compromise that mark constitutional moments fertilize vagueness in facilities. And when the in 145 that mark constitutional moments fertilize vagueness in facilities. And when the in 145 that mark constitutional moments fertilize vagueness in facilities. That constitutions born out of long-drawn compromises such as ours tend to create. My Lord, the spirit of the Constitution has to be invoked by the court as a such. And for the My Lord, the spirit of the Constitution has to be invoked by the court as a such. And for the how is it that the drafters could have intended that Senate can investigate these serious charges in plenary without saying so? How can such a serious provision be left to inference by a technical interpretation of the word may, that because it says may, that's discretionary? What about the and before the may? My Lord, how could the drafters have intended that Senate could investigate in plenary within 24 hours, even denying the subject of the impeachment a fair hearing? I turn to an issue of comparative constitutionalism. My Lord, no other country has a similar kind of fast-track impeachment that can be done in 24 hours. No other democratic country, at least according to my research. South Africa has the panel at Article 89 of its constitution. We call it special committee. South Africa calls it independent panel. The role of that independent panel, Section 89 South African Constitution, is to determine if sufficient evidence exists of a serious constitutional violation before the National Assembly votes. The role of this special committee was to sieve off some of these things that we are now confronting you with. Section 132 Penal Code, nullified. How can it form an impeachment charge? United States uses the House Judiciary Committee to investigate the charges. My Lord, in Nigeria, Article 143.5 of the Nigerian Constitution, there's a panel of 7 members appointed by the Chief Justice of persons of unquestionable integrity, but who are not politicians or civil servants for independence. Panel of 7 appointed by the Chief Justice. If my learned friend, Professor Ogenda, were not a senator, but were a Nigerian citizen, he would sit definitely on this panel. In Philippines, Article 11, Section 3, that it's called the Committee on Justice, this special committee. In South Korea, Article 65, the committee is called the Legislation and Judiciary Committee. It investigates the charges after a motion is proposed, though the Constitutional Court ultimately will adjudicate the trial. In India, Article 61 is called Investigating House Committee. My Lord, the long and short of it is that what we had here was not a constitutional process that is worthy of this court's protection. If you faithfully interpret Article 145, if you just have one look at Standing Order 78, at Standing Order 80, if you look at the rules of procedure, Rule 2, and then you spend time, my Lord, with the history of Article 145, you will arrive at one inevitable conclusion. That is the conclusion that failing to appoint the special committee required by Article 145(3), my Lord, grossly violated the Constitution. And that violation was not harmless. It bogged the Senate down into a fictitious timeline. It said we are not appointing the committee, we have two options. No, they did not. But then they retained the 10-day given to that committee and said they're using that for the plenary investigations. What do you have? You have a sham of a trial. And in trying to punish the man, Rigathi Gachagua, in that way, the Senate and the National Assembly demeaned his office. They demeaned the office while trying to punish the man. And in demeaning the office, they, my Lord, grossly violated the Constitution. My Lord, thank you for the opportunity to address you.
I think we have made good progress with adjourn for lunch, then we come back.
That's right.
Thank you so much. You brought that argument. You know that argument yesterday I used very fast. Yeah? But after a while it began making a lot of sense.
In this case. And finally, it records here that the plenary, sorry, it also says that there are some benefits to the plenary report as well. My Lord, in short, what you are saying is that the motion to impeach the deputy president was contingent